I don't even know what to call it. I wouldn't call it a conspiracy because it's just like stupid. It's just negligence, you know. Let me read you the rest of this passage. If substance abuse testing is ordered by the court, the test should be performed in conformance with procedures and standards established by the United States Department of Health and Human Services for drug testing of federal employees. The parent, legal custodian, person seeking guardianship, or person seeking visitation in the guardianship who has undergone drug testing shall have the right to a hearing if requested to challenge a positive test result. This happened, and I did, and I passed my urine test. A positive test result, even if challenged and upheld, shall not by itself constitute grounds for an adverse custody or guardianship decision. Let me read that again. A positive test result, even if challenged and upheld, shall not by itself constitute grounds for an adverse custody or guardianship decision. Okay? Determining the best interest of the child requires weighing all relevant factors, all of them. Not some of them, not 2 or 3 of them, all of them. The court shall also consider any reports provided to the court pursuant to Probate Code. Oh, and to add insult to injury, I just totally forgot this part. When I went to court with Miss Tara Howard, she was like, I'll never forget, she was like excessively rude for like no apparent reason, and it just led me to believe that she had something to do with all this stuff going on. Because who is like a brand new judge? You're learning like what you're barely learning, especially in a county that like just went through this drastic change in 2001, was it? That like all these municipal judges became superior court judges now, and they have all this like power that they don't, are still learning. You would think they would have humbled themselves, or like somebody would have told them like, hey, take it easy on your, your first couple of years. She basically wanted to talk to me like she's God and she's like has the right to take my child from me. Anyway, I need to finish this. The results of this testing shall be confidential, shall be maintained, okay, let me read that. The results of this testing shall be confidential. Oh my God, people need to learn how to count. Confidential, right? So that didn't happen. And then I was accused after the hearing, accused of trying to remove some chemical from my hair so that my so that my test would come out clean, apparently. And so others present in the hearing were also like looking at me like, what? Like, oh my God, like you're because of what Tara said, Miss Howard, what the Honorable Miss Howard said, and I don't even think it, like, what was the point of that? Did that help my son's well-being? Anyways, it says, shall be maintained in a sealed record in the court file and may not be released to any person except the court, the parties, their attorneys, the Judicial Council until completion of its authorized study of the testing process. I'm not even sure how this process works, by the way, because according to my research, there is no actual way to make this testing, this is a word that always escapes me, but basically to make it like across the board reliable, right? Because of how different all of our hair types are, there's no way that you can compare one hair test to another. But apparently these people have it all figured out. Mind you, it wasn't like I was even denying my use of drugs. I was denying it being anybody's business. I wasn't doing anything that was, well, anything basically other than my job, doing my job as a parent who happened to have personal struggles to deal with and didn't feel the need to explain them all to the court, just like I don't go and explain everybody else's business to the court. That's not my business, right? But yeah, apparently this was ignored. I'm missing something. The result of this test shall be except the court will include an authorized study of the testing process. Any person to whom the court expressly grants access by written order may, with prior notice to all parties. Access by written order made with prior notice to all parties. Yeah, so this is obviously like a very personal thing, and it's very clear in the section that I did mention to the judge in court, to my lawyer, James Vallis, he's from Kingsburg, and to the CPS, the person that called from CPS, I don't recall her name, all the paperwork that I had on the you know, there were break-ins to my house. A lot of things have happened since then. I've lost a lot of the information, but obviously it's all accessible. The clerk has records of this stuff, and so do all the parties. So like my mother-in-law or my and so his dad basically would have whatever. Person authorized to receive. Any person who has access to the test results may not disseminate copies or disclose information about the test results to any person other than a person who is authorized to receive the test results pursuant to this section. Any breach of the confidentiality of the test results shall be punishable by civil sanctions not to exceed $2,500. The results of the testing may not be used for any purpose, including any criminal, civil, or administrative proceeding, except to assist the court in determining, for purposes of the proceeding, the best interest of the child pursuant to Section 3011 and the content of the order or judgment determining custody or visitation. The court may order either party or both parties to pay the cost of the drug or alcohol testing pursuant to this section. I was ordered to pay. I did private pay for a lot of these because it was so inconvenient to get an order from the court. They never had the paperwork ready after the court was adjourned. Like, oh, we had to do this. They were very forgiving about the mistakes that they would make, but if you made a mistake, it was the end of the world for them. The court may order either party or both parties to pay the cost of the drug or alcohol testing order pursuant to this section. See, that's what should have happened here, since I'm being accused of using a drug and I have no criminal convictions, felonies, stuff like that. I have one charge where I told a lie to a police officer, basically said that drugs were mine when they weren't. That was the only thing on my record, like, for life. And I mean, apparently it was used against me, it looks like. Yeah. So purpose of the proceeding, which was in 2011, by the way, and I had my son in 2012, so that was before I even knew I was going to have a son. I was actually right before, I think I stopped talking to the dude after that drug thing because he continued to use drugs after I went to jail for him. Like, that was ridiculous. Such a dumbass. Anyways, the purposes of the proceeding, I lost my spot. The results of the testing may not be used for any purposes, including criminal, civil, or administrative. Dude, I basically licked the court's butthole. I did every fucking thing that they asked, and it was like nothing was never good enough. So here we are. As used in this section, controlled substances has the same meaning as defined in the California Uniform Controlled Substances Act, Division 10, commencing with Section 11,000 of the Health and Safety Code. You know how many, every single parent I know has drug convictions? Far more than I have, and several felonies and several misdemeanors, traffic offenses, DUIs, I mean, you name it. They have complete full custody of their kids. I mean, some of these people went as far as to accuse me of being crazy enough to try to kill myself. I mean, I definitely had bad days, but I mean, have I ever purchased a gun? Do you see me like buying ropes and shit? And like, wow. Do you see me doing things where I'm risking my life constantly? Because I see people doing that, but I don't see me doing it. This was Family Code Section 3041.5, and it was last updated January 1st of 2019. When I first read it, I do remember it was a little different. I think it was last updated before that, 2011 or I don't know. It had been a few years back, but not much has changed. The text is pretty clear on what is considered just. So naturally, you can see my frustration because I don't even know how to proceed with something that's like already garbage in the first place. Like, I have to go file to ask for custody of my own son, who was already in my custody, without being given a reason for why he was taken. Like, I was told to do a drug program, but what's the basis for doing the drug program if your laws state that I passed your stupid test, which is invalid to begin with? Oh, wow.